Thank
Yes,
you.
Mr. Clark.
Yes. The second issue that arises is...
Sorry, I just see we've got some, you've given us some more material.
Yes, apologies.
We've got
There,
concurrent leases.
I do apologise. Yes, there's the question of the extract from McGarry,
Yes.
16.134, and your Lordship is correct this morning. It is a matter of common law,
Yeah.
not statute. And there's an explanation there with citation of various authority in the footnotes. But it is a common law rule in relation to an assignment.
Yeah.
And then the other material relates to paragraphs 82, I believe 82 and 84.
Yes. So these were instances of if and only.
Yes, that is right.
Yes.
Yeah.
So we're going to now. This part you say the Deputy President was wrong to say that Part 4 could apply.
Yes. So of course, if and insofar as you are with me with respect to the first issue, the second issue will not arise because of course APW has the opportunity of utilising Part 5.
Right.
So Part 4 as a solution arises only if the first issue is decided against me and you uphold the Deputy President's view.
So we approach this on the basis that APW is not a site provider who is a party to a code.
That is right. That is right. Thank you. So in those circumstances, what we say and what we submitted below was that if Part 5 is engaged at all, Part 4 is unavailable, and we relied upon the decision of Compton Beecham in the Supreme Court, and the Deputy President touched upon the point, or recognised the point, at paragraph 117, 117, page 94 of the core bundle.
Can I just understand where we get to on this? We approach this issue on the basis that your clients, and indeed Vodafone, can't invoke Part 5. If you're right about this, then is everybody paralysed forever?
If I'm right about this, meaning
This
cannot
issue.
invoke Part 5.
If Part 4 is not available and Part 5 is not available, everybody's completely
Well, then it would
stuck.
appear the code breaks down.
And then what?
And then the you have the scenario of the code agreement continuing, because that's what paragraph 30 appears to indicate.
Yeah.
Doesn't require there to be another party. Its rights are simply continuing. And it just breaks down. There is no one who can terminate it, certainly not with respect to the concurrent lessee. It may be once the concurrent lease is determined, there will be someone above the chain that says, I'm not bound, and then seeks removal under Part 6. Because obviously if you're not bound, you can seek removal of the electronic communication.
So in the case of a 125-year concurrent lease, for instance, this would just roll on.
It would just
for
roll
100
on.
years.
And
No
that's
matter
why
that the technology is completely out of date and unusable, and nobody can.
And that's
do
why
anything.
I said to in answer to a question from my Lord Justice Nugee, you could have this scenario of, I wouldn't call it perpetual, but given that the operator is the party in the driving seat, even on the Deputy President's solution, if the Deputy President's solution is unavailable, you have the same result in the sense that Part 4 is optional. It's not a mandatory requirement to initiate it on the part of the operator. It doesn't
No,
have
that
to.
I understand, but you say even if
Yeah,
he wants
well,
to, the operator can't.
Even the operator can't, yeah.
All right.
It's really another argument in support of your first.
It is, my lord. Yes, absolutely.
Not really,
Absolutely.
it's not really an independent.
It's not an independent. I would fully accept that. It highlights the absurdity of why it is we should be treated, not the absurdity.
Yes, it's in the terrorum of us finding against you on
Well,
Part 5.
I depends how one wants to take that. So, yes, my lord. Sorry, I was going to go to paragraph 117.
Yeah, and this all turns on a few paragraphs in Lady Rose's judgment.
It does, and what what Compton Beecham says is that you cannot access Part 4 during the contractual term. You have to be held to your bargain. So you cannot seek, in quotes, renewal, unquotes.
Get new code rights. You can have new code.
You have new code rights, or yes, you can have new code rights. What you cannot have is a completely new agreement by way of a renewal. That is provided for by Part 5.
Yeah.
So it's the sole remit of Part 5. That's what she said. And so the question then arose before the Deputy President, well, has Part 5 been engaged? Because if Part 5 is engaged, then Part 4 on the face of it is unavailable for renewal, because what Vodafone is seeking is not simply any additional code rights, it's seeking termination together with a completely new agreement. That's what it was wanting.
I think at some points in her judgment, Lady Rose talks about an agreement to which Part 5 applies, and in other parts she talks about Part 5 being available.
Yes, yes. Yes, that is true. It depends how you want to construe that. I mean, the question here, of course, is that the Deputy President had to recognise that Part 5 did apply because there was a continuation of the Code Agreement. Paragraph 30, subparagraph 2 was triggered. So he recognised that at paragraph 117 of the judgment. He says, if I may just take you to that.
Yeah.
Page 94, my lord. The solution to the problem highlighted by this reference appears to me to be available in Part 4. I appreciate that Lady Rose stated at 128 that it is sufficiently clear from the Code read as a whole that Part 4 does not apply to code rights to which para 30, subparagraph 2 applies. It is also the case that the original agreement is continuing under paragraph 30, which ordinarily would exclude the application of Part 4. But in this case, the Code Agreement is continuing in circumstances where the provisions of Part 5, dealing with termination, variation, renewal, are not available to the parties. Lady Rose's observation was addressing the submission that there is nothing in Part 5 itself to say that it applies to the exclusion of Part 4 once Part 5 becomes available to the operator under the agreement. She was not considering the anomalous situation where, despite the agreement being continued, Part 5 is not available. Of course, what he's talking about there is not available to the site provider that would be treated as the occupier under paragraph 105 and the operator in situ carrying on the telecommunications business. So what he's trying to do is to provide a nuanced approach to Part 5 by saying, well, it is true that Part 5 has been triggered, but Part 5 is not available to these parties. And therefore, because it's not available to these parties, notwithstanding the fact that it would, APW would be treated as the occupier, it's still not available to these parties. Therefore, I can find that Part 4 has an avenue for operation. Now, one of the problems about that, of course, is that the respondent is asserting in its skeleton argument that it is, notwithstanding the difficulty that APW finds itself in, able to terminate the Code Agreement. So on the face of it, the respondent is contending that Part 5 is available to the parties to the Code Agreement. So it's difficult to see how one can say it is not available, even in the context of the parties to the Code Agreement, because it is asserted by the respondent that it is.
Well, according to the Deputy President, wrongly asserted.
Well, yes, the Deputy President doesn't make, I believe, doesn't make a specific finding that Gencomp was unable to terminate. He does say specifically that Gencomp is not the occupier and therefore is unable to confer code rights. I do not believe he makes a specific finding that Gencomp could not terminate. I mean, 117, one could suggest that by implication he is stating that the provisions of Part 5 dealing with termination, variation and renewal are not available to the parties. So there is, in his mind, the view that termination would not be available under paragraph 31. And then he goes on at paragraph 118. Part 5 deals only with termination, modification, renewal of agreements between the original parties and their successors. It does not apply where the operator and the occupier of the land in respect of which rights are sought are not both parties to the agreement or their successors. So, looking at that particular paragraph, he again is concentrating on the parties who are the occupier and the operator in relation to the site. We, APW, is the occupier, operator Vodafone, they are parties, Part 5 is not available to them. So Gencomp, it would appear, could still seek to terminate. It cannot confer because of Compton Beecham, but query, as I say, the Deputy President doesn't appear to have made a specific finding about termination. The respondent is averring that it can terminate, and if that's the position that it's putting forward, then Part 5 is engaged, in which case Part 4 should not be engaged. If the court is against APW in relation to the first issue about Part 5 applying, and if it is the case that the court were to find that Part 5 is not engaged, then it does, in our respectful submission, require some clear guidance from the court as to what circumstances there is, as it were, a carve-out from Compton Beecham. Because is it the case that for the purposes of enabling one to utilise Part 4, it is sufficient that you cannot seek renewal only? It matters not that the code agreement is continuing under paragraph 30, subparagraph 2, and it matters not that the Gencomp, the superior landlord, party to the conferring agreement, could seek to terminate, and therefore the carve-out, as it were, to enable one to seek to utilise Part 4 is limited to the circumstances where you cannot seek a right of renewal. Now, that in my respectful submission, would require some very clear guidance from the court to that effect. We say, however, that it is sufficient that paragraph 30, subparagraph 2 is triggered. The interesting thing about paragraph 30, subparagraph 2 is if one goes back to it, which is tab 21 in volume 2, page 436, paragraph 30 says subparagraph 2 applies if the code of right is conferred by or otherwise binding on a person, the site provider, as a result of a code agreement, and B, etc. Where this subparagraph applies, the code agreement continues so that the operator may continue to exercise that right. The site provider continues to be bound by that right. For the purposes of paragraph 30, subparagraph 2, there is no requirement there for the site provider to be a party to the code agreement. It's sufficient that you are bound.
Well, that's clear from the contrast between paragraph 30 and paragraph 31.
Yes. So when it's said that by Lady Rose that Part 5 or Part 4 isn't available if Part 5 is triggered, then Part 5 is triggered in our respectful submission, in which case Part 4 should not be available. So we do end up in the scenario that my Lord Justice Lewison mentioned at the beginning, which is that you have this absurdity of yet another of neither party being able to do anything, including the operator. But that in itself is not a justification for producing an asymmetrical arrangement. There's no justification for doing that. Give me a moment.
So going back to what Lady Rose says,
Yes, my lord.
tab 14, this is a paragraph 127, page 320. The submission that was made on your client's behalf by Mr. Pine
Yes.
is at F. There's nothing in Part 5 to say it applies to the exclusion of Part 4 once Part 5 becomes available to the operator on this agreement. She says at 128, I don't accept that. Sufficiently clear in the code that Part 4 does not apply to code agreements to which paragraph 30 subparagraph 2 applies. And then she gives some reasons. And then at 129...
Well, just before that, my lord, if I may interrupt you, she says that between A and B, parties are correct. She reiterates the 30 subparagraph 2 point. On page 321, in paragraph 128.
Oh, I see.
Between A, but the parties are
correct in accepting that Part 5 is only available. Right. Then at 129, she says that's why Part 5 applies to exclusion of Part 4 once Part 5 becomes applicable to a code agreement. Don't accept you need to construe occupiers, including the operator, in order to ensure that Part 4 does not apply to a code to which paragraph 32 applies. So you say that although there is a reference in paragraph 127 to Part 5 becoming available, what she means by that, as we see from 128 and 129, is an agreement to which paragraph 30 subparagraph 2 applies.
And it applies...
And it applies here, therefore Part 4 is not available.
That is so.
And is that part of the ratio of Compton Beecham which is binding on us?
In my respectful submission, it is. It is, because in order to ascertain whether or not you are able to utilise Part 4, you have to determine whether or not Part 5 has become engaged.
Yeah.
So, moving on from the question of engagement, I'd like to move on now to why it is we say Part 4 is inappropriate. What is it about Part 4 that requires this court to reject the Part 4 avenue as a solution to the problem?
Well, the first ground for rejecting it on your submission is that we're bound by the Supreme Court to do so.
Yes.
And that's the end of that.
That's the end of that. But you may find that on further consideration, you're against me. So I would like, if I may, just to highlight a number of points as to why Part 4 is inappropriate, even if, notwithstanding what I've said about why Part 5 is engaged. May I just highlight a few points on the inappropriateness of Part 4? The first is a point that I've already made several times today, which is that it is available only at the option of the operator. There's no mandatory requirement to utilise it, and therefore we have this scenario that I've already indicated that could happen of the operator just sitting there. Secondly, it doesn't deal with termination. So it's an obvious point, but and the Deputy President recognised that. He referred to that as a small problem. We say it's quite a bit more than a small problem in terms of the solution. The third point is that the Part 4 solution sidesteps the notice requirement of paragraph 33. That's a 6-month notice requirement, as opposed to a 28-day notice requirement in paragraph 20. And the fourth point is that the operator under paragraph 20 has to justify the entitlement to the new code agreement in accordance with paragraph 21, which it doesn't have to under Part 5 on renewal. So on the renewal, there's, as it were, a presumptive satisfaction of the public benefit test that one finds in paragraph 21, and yet it then has to find itself having to justify the imposition under Part 4. Now, that's more than just a technical point, because undoubtedly it will be said vis-à-vis the operator, you already have a code agreement which confers upon you sufficient code rights. You do not need a new agreement in accordance with Part 4, and therefore you do not satisfy the public benefit test. You already have the rights that you're seeking.
Can I raise a question?
Please, my lord. Yeah.
Which may not be a question for you. Why if you're right that section 32, paragraph 32 continued disagreement, why did the operator want a new one?
That's a good question, my lord, and it may, as you say, be something for Mr. Reed. In relation to this as an issue, it must be pointed out that this is the only operator prior to the institute of this reference that argued that APW as a concurrent lessee was not in a position to confer rights in accordance with Part 5. No other operator thought there was a problem with APW's position. And moreover, there are cases that have been decided by the Upper Tribunal. Without this, it must be said, this point being raised, but the Upper Tribunal itself, as a specialist tribunal, saw nothing problematic with APW being a party to a Part 5
You've done
renewal.
this on lots of sites. This is your business.
We've done this on lots of sites and been the subject matter of decisions last year. There are at least 5 in which I was involved in where this was not problematic.
Point was never taken.
Point was never taken.
It still doesn't quite.
No, but
because the submission, the thrust of your submission is the operator's sitting pretty. You can just sit there and carry on paying the rent he was previously agreed, ad infinitum. Well, at any rate till 2058.
Yes, in which case it may, if the appeal is dismissed, operators may decide that that is the avenue which they wish to adopt. This, as it were, is a test case to determine the extent to which APW or a concurrent lessee can be involved. It may be just a commercial consideration that they want to not deal with APW, who are likely, being the person most immediately interested, to be more difficult, in quotes, with respect to dealing with the terms of renewal, whereas someone who is up the chain, such as Gencomp, is not going to be particularly bothered about the terms of the agreement they agree to. And we know that here, coming back to the facts of this case, but we know that here because Gencomp have not participated. They didn't want anything to do with the
They said they'd do whatever.
Do whatever, yes, whatever the tribunal decided. So it may be that Mr. Reed may be able to explain, but that it seems is either operators are going to change their tune after this case, if this case is dismissed, if this appeal is dismissed, or it may simply be a commercial consideration. They thought they'd be better off dealing with Gencomp. Yes, so reasons why it's inappropriate. As I said, it removes the presumptive satisfaction of the paragraph 21 test. And then the next point is that, of course, the application under paragraph 20 contains within it a provision entitling a site provider to seek to resist imposition. That's the paragraph 21 subparagraph 5 provision that deals with redevelopment. So if you're intending to redevelop, you can say, I don't want this agreement. Now, we say, well, that's completely illusory if the respondent is correct, because it has an existing code agreement which is incapable of termination by APW, incapable of renewal by APW. It asks for a Part 4 agreement. We succeed in resisting that, and they'll say, well, so what? Thank you very much. We still have a code agreement that hasn't been terminated. It's the whole basis of the entitlement to oppose is undermined. It's a risk-free approach for the operator. Then the next point is that Part 4 is, as we see it, a blunt instrument. It's unclear what is to happen if the operator simply wanted a modification, because Part 4, it's difficult to see how the operator deals with just a straightforward modification. So those are a number of reasons as to why we say Part 4 is inappropriate. And then the next issue is this question that I touched upon in opening as part of the preliminary factors I wanted to draw attention to, which is that the respondent, Vodafone, recognises that it may have to do something with the conferral agreement, because Gencomp is a party to the agreement which Vodafone has and APW is not. Then it is concerned to deal with that, because it's rather difficult to see what would happen to that agreement, and therefore they want to use, as it were, the statutory magic of the code. If you recall, when we looked at paragraph 34, you had statutory direction for termination and a new agreement. And what they wish to do is, they say they are entitled to make a Part 5 claim against Gencomp, in quotes, for renewal, unquotes. That application is, however, not an application for a new conferral agreement, but to transpose or flip, as I would like to refer to it, flip the conferral into one which is a binding agreement. So now Gencomp is going to be bound on the application under Part 5 vis-à-vis Gencomp to the code rights that are going to be conferred upon Vodafone by APW pursuant to the Part 4. So
why is that necessary? Why can't?
Well, we say that it shouldn't be under Part 5, it should be under Part 4. We don't see any problem with Part 4.
Because if you grant code rights to Vodafone can ask under paragraph 20 for Gencomp to be bound by those rights.
That's right. We see no problem about that. But the way your lordship read paragraph 122 of the Deputy President's judgment, which was that it was a matter that was being dealt with under Part 5, that is how I read it.
Part 4.
But, sorry, thank you so much, my lord. Yes, Part 4. However, the respondent's skeleton maintains the position that it was an order being made under Part 5.
The problem is, how do you terminate your existing Part 5 code agreement? Isn't that the problem?
Well, that's one of the matters that is of concern to Mr. Reed. But we're having all of this sort of convoluted debate because APW is out of the picture. If APW is a party to the code agreement, none of this arises, because you then have the statutory magic.
Why can't it just terminate under Part 5 against Gencomp?
The scenario being is that Part 4 is ordered vis-à-vis APW, and then there's a claim against Gencomp under Part 5 or Part 4?
Under Part 5, just to terminate.
Yeah.
You don't need to renew. You can't just terminate.
There doesn't appear to be a provision simply for termination.
Oh, am I wrong about that?
Well, on the renewal, because of course one mustn't forget that this is a claim for renewal. It's not a claim for termination under paragraph 31. If one goes back to the code, the paragraph 33 is telling us what it is that can be done. 33.1 at page 438.
I'm sorry,
there is, to my knowledge, no provision for termination per se.
There's no provision for an operator to terminate. There's 31, but that's only for a site provider to terminate.
That is right. Your Lordship's identified another lacuna in the code, which is that there is no express provision providing for termination by an operator. It's slightly odd why that's the case, but there's no express provision saying, for instance, that the operator can terminate its code agreement by doing the following.
Paragraph 33.1d is about as close as you get.
Yes, that's as close as you can get, but and a new agreement shall have effect. So it's not just termination. Now, the issue about how an operator terminates its code agreement, obviously if the parties agree to a new agreement, then one would necessarily say that there must be some form of rescission or surrender, whatever the nature of the arrangement is, if it's contractual rescission, lease, surrender, giving rise to a termination of the operator's agreement. But there's no clear...
What happens if the operator, in effect, says to the site provider, well, I found a better and a cheaper site down the road.
I'm going away.
I'm going away.
Yeah.
And the site provider can say, well, I don't want you to, you carry on paying the rent?
If it's during the contractual term, then he's caught by the contract. Let's assume there's a break clause. He terminates the contract by a break clause. Then one then has to grapple with paragraph 30 subparagraph 2. But paragraph 30 subparagraph 2, in my respectful submission, could be said to be subject to a requirement as under the 54 Act, which is that it is a requirement of paragraph 30 subparagraph 2 to be triggered and to continue the continuation for the operator to be utilising the site for the statutory purposes. Because paragraph 3, a code right is only a code right in relation to land for the statutory purposes. And if you are not utilising the land for the statutory purposes, you are no longer you no longer have anything that qualifies as a code right. So you
go back to paragraph 30. Subparagraph 2 applies if a code right is conferred by a person as a result of a code agreement. Well, you've got a code agreement and it confers a code right. B, under the terms of the agreement, the right ceases to be exercisable. Right. Operator gives notice, therefore the right ceases to be exercised.
Yes.
And then subparagraph 2, where this subparagraph applies, the code agreement continues.
Yes. So on the face of it, it continues. But that cannot be right. That's not how the code should work, obviously. It must be the case that the operator could walk away.
Well, you would have thought so.
You would have thought so. And the only way I have been able to thought about this quite a bit, there's no guidance in any of the case law. It seems to me that the only way in which one can try to justify that is some sort of continuity argument, that you have to be in occupation, like the 54 Act, given that the code was based on the 54 Act, like the 54 Act, there has to be a continuity of occupation for the statutory purposes, otherwise your rights come to an end. Like the 54 Act, if you're not occupying it for the purposes or partly for the purposes of business, your rights come to an end. But that's a matter for another case. But
it provides that the operator may continue to exercise the right. It doesn't provide that it must continue.
No, but if he may, but then what happens to the agreement?
What happens to the rent? Does he have to carry on paying rent if he doesn't want the land?
Well, isn't it the case that the agreements come to an end? And these are effectively rights which are designed to protect the operator's
I accept
ability
that.
to continue to use the land for these purposes. If it doesn't wish to,
then it should be entitled to walk away. I don't dispute that. I would accept that an operator should be entitled to walk away. How one achieves that by reference to the code is very difficult. But
maybe he could apply under 33 for the terms to be modified so the rent is reduced to a peppercorn on the basis he has no further use for it. But it all seems very artificial.
Very artificial. Very artificial. And that's really, as your Lordship has mentioned, this is why we say this sort of Part 5 order is all very artificial. We see no objection to Part 4 being utilised to make Gencomp bound, but not Part 5, which is a renewal of the conferral agreement, to make Gencomp bound by different code rights. It just seems to us that is not an appropriate way of dealing with it. And we read 122 as not referring to Part 5, but as referring to Part 4. And as I say, they did serve Part 4 as requiring Gencomp to be bound.
There were a whole suite of notices, alternative notices.
Yes, there were.
Well, what is the actual decision of the Upper Tribunal? Which notice is effective?
I'm not able to say, given that there's no specific notice refers to of the however many.
These are only preliminary issues. So
yes. There were a number of notices, a considerable number under para 33 and a number under para 20. As I read 122, there's no specific notice that is referred to, simply that an order could be made making code rights conferred on Vodafone by APW binding on Gencomp. We say in context that must be dealing with Part 4, not Part 5. Give me a moment. Yes, and there's a modicum of support we would respectfully submit in relation to this argument that you cannot transpose or flip from in a renewal under Part 5 from that being a renewal and transforming it into a binding agreement. The Deputy President at paragraph 111, page 93 of the bundle. Page 93. Does say in the middle of that paragraph, beginning, it appears to follow, your lordships have that?
Yeah.
Appears to follow that the only person who may be the subject of a request to enter into a binding agreement under para 33, i.e. Part 5, is the other party to an existing binding agreement. So he does not appear to be contemplating in his mind that a request to enter into a binding agreement can be made under paragraph 33 to a party who is not a party to an existing binding agreement, but a party to a confer agreement. The other point about trying to have this two-stage process of utilising Part 4 against APW and then still being able to maintain a renewal, in quotes, against Gencomp under Part 5 is of course that, and it may be said that this is a matter for the lookout of operators, but the timing is very different. Part 4 is 28 days, renewal is 6 months, so there's going to have to be some juggling of timing in relation to when they're going to serve these notices to ensure that they're heard at the same time and the appropriate orders can be made at the same time. So that in itself suggests it's, as your lordship said, artificial. There's a small point that I make in the skeleton. I don't wish to make any oral submission or submissions on it. It's a very small point on paragraph 100. If I could just ask you to make a skeleton argument on that, is paragraphs 72 to 76 about the impact of paragraph 100. It's a small point, just a, as it were, an additional point. It's not a primary point. Just
I have the page number.
Thank you,
36.
Thank you. Thank you. Then the final point, I believe, on this is that if your lordships are against me on the Part 5, against me on the Part 4, then the final argument on behalf of APW is that if and insofar as Part 4 is available, it should, consistently with Compton Beecham, be available only for new code rights, not a complete termination and renewal. They already have code rights. If the underlying principle is that you have to, as it were, be bound by your agreement, parties should be held to their contracts, said Lady Rose, then given that APW is bound by the terms of the existing agreement, which contains code rights for Vodafone, which APW cannot prevent Vodafone from exercising, then our submission is that consistently with Compton Beecham, Vodafone should be limited to making an application only for new code rights, not a complete, in quotes, renewal.
Well, that begs the question of, as Lady Rose recognised, what is a new code right?
Well,
if I have the right to maintain electronic communications equipment on your roof for 10 years from 2013, and I now have an indefinite but unquantified right because of paragraph 32, and I say, well, now I want another 10 years, this time from 2023, is that a new code right?
Well,
didn't have it before.
No, it's that is a difficult issue. It was Lady Rose did make a comment about that, recognising that there could be difficulty, but she felt that the Upper Tribunal would be able to deal with that
without difficulty. Yes.
Yeah, and it is fair to say that the Ashlock decision was referred back to the tribunal to determine whether what was being sought was new code rights or a completely new agreement. So, yes, it's a difficult issue. If you recall, my lord, some time ago now, your lordship may not remember it, But in Compton Beecham, in the Court of Appeal, one of the issues was the extent to which, forgive me, Ashlock, I think it was, the extent to which a variation of the hours of access was going to be a variation or a new code right. Court of Appeal thought it was a new code right. Thought it was a variation, whereas the Supreme Court suggested it was a new code right. So it's impossible to tell. At the moment, there's no clear guidance as to in what circumstances something will be viewed as a new code right or a completely new agreement or modification. It's a weights determination. Then there was one final point I wanted to mention in answer to a question, I believe, from my Lord Justice Nugee about what happens if someone is seeking rights going beyond the term of the concurrent lessee. You have a very short concurrent lease, what happens? There was some consideration of that in a case called E.E. and Edelweiss, if I may just hand that up. Your Lordships may find out.
E.E. and who?
E.E. and Edelweiss, spelled Edelwind.
Yeah. This is Upper Tribunal, is it?
It is, my lord. It was Judge Elizabeth Cook. And I happened to be in this case, which was a case where there was a freehold tenancy operations agreement. The tenancy had been determined by a break notice up the chain. It's accepted, therefore it destroyed all contractual interests. The freeholder had entered into a binding agreement, and what we wanted to do was to terminate the binding agreement. And Judge Cook said that conferral agreements and binding agreements, what she called secondary code agreements, she made this distinction between primary, the conferral, and secondary, being the binding, are to be treated independently and can be terminated independently. But she did touch upon why it may be that the occupational operator may want to seek further rights going beyond the term of the intermediate lessee. And she deals with that at paragraph 40. Perhaps if I could ask your Lordships to read 40 to paragraph 46.
Yeah. What's the secondary code agreement?
The secondary code agreement is what she... The secondary code agreement is what she called a binding. The binding agreement she identified or gave it a label.
Right. That's what the Deputy President called a binding agreement as opposed to a conferring agreement.
Conferring, and Judge Cook referred to the conferring agreement as the primary code agreement. Thank you, my lord.
40 to 46.
Yeah, 40 to 46, first sentence, second sentence of 46. Thank you. Yes, so she contemplates this idea of going up the chain because you want something longer. My lords, unless I can assist you further, those are my submissions.
Thank you very much.
Thank you so much.
My Lord, can I start with raising something that we did not think was actually an issue? Our position was that if we want Gencomp to be bound, then that code agreement must be pursuant to Part 5 of the code agreement. APW appeared to suggest that that was not clear from the terms of the judgment. But we say it was crystal clear from the terms of the judgment. And can I illustrate that by taking you to the core bundle at tab 4 and asking you to go to paragraph 53, which occurs on page 82, and see what it was that was actually being dealt with in the preliminary issue, because these were preliminary issues as the court has already identified. One can see that issue 3 is if the tribunal is to order the termination of Vodafone's existing lease and to direct the parties to enter into a new agreement under paragraph 34(6) of the code, which of the respondents is the correct party, A, to confer the rights contained in the new agreement on Vodafone, and B, to be bound by those new rights. And thus, when one comes to paragraph 122, which is on page 96, when in that final sentence in the paragraph, the Deputy President says the answer to the third preliminary issue is that no order may be made under paragraph 34 for the conferring of a new agreement on Vodafone, but an order could be made making code rights conferred on Vodafone by APW binding on Gencomp. Now, what we understand by that is that the code rights that it was anticipated by the Upper Tribunal would be conferred on Vodafone by APW under Part 4 would then be subject to a binding code agreement under Part 5 against APW. So this is a point that's not been raised in the skeleton argument. We think it's absolutely clear from the judgment, and it's certainly always been our case that if the APW has to have rights conferred under Part 4, the way that that must be dealt with as regards Gencomp is for an order under Part 5 because it is most certainly the party to a code agreement for the purposes of paragraph 33(1). Now, this is quite an important point in our respectful submission, particularly in the context of this case, because there is a point, and this is the reason why the question of notices was not fully decided. The problem is there's still a big issue bubbling away in the background about whether or not APW can confer all the code rights we actually need. There's the argument about, for example, the concurrent lease area and whether it covers the whole of the roof site, and the argument about whether or not the rights relating to the rest of the building we would need a code agreement against against Gencomp in any event. Now, one obviously doesn't go into that for the purposes of this hearing, because obviously those are all matters that were going to be dealt with in the subsequent trial process. But what it does demonstrate is how important it is that at very least Part 5 should be available to a party like Vodafone in order to ensure that whatever code rights are conferred by APW are binding on Gencomp. And it's very important, we say, in the context of situations like this, because even here, we could, there's a clause in the concurrent lease that says that APW can terminate its concurrent lease on 1 month's written notice. It can walk away from this concurrent lease on just giving 1 month's concurrent notice. Now that illustrates precisely the reason why, if anything else in this case, we want Gencomp bound in to any code rights we may get from APW under Part 4.
I think that's disputed. The question is how.
Well, that's absolutely right. But I'm making the point that on any view, we will have to have a binding agreement against Gencomp. As it is a party to the code agreement, we say it falls squarely within the wording of paragraph 33(1). And we say it's quite an important point in all of this because although my learned friend was asked about it several times, we still really don't understand whether he is saying that APW, on its case, substitutes Gencomp as the party to the code agreement under paragraph 33, or whether or not they're joint with Gencomp under party 3, under paragraph 33, as both parties to the agreement. And we say it's an important point when one comes on to consider this question about whether or not APW can really be a party to the code agreement for the purpose.
So just looking at paragraph 33 for a moment,
Yes.
on page 438,
33(1).
An operator who is a party to a code agreement, that is Vodafone,
Yes.
by which a code right is conferred, that's the existing
Code agreement.
may by notice require the other party to the agreement, that's Gencomp,
Yes.
to agree that
And then D.
the existing code agreement should be terminated and a new agreement should have effect between the party which provides for a code right to bind the site provider, that code right being that which has been conferred by APW on Vodafone under Part 4.
Exactly, my lord. That's the point in its entirety. I want to start, having made that preliminary point, I want to start by just dealing in overview about why we say the way that APW has been looking at the interpretation of the code is simply wrong. And that the way one should approach the construction of this code is by looking at what the underlying purpose behind the code was. And we say it's clear from the language and indeed from various other indicia in the cases subsequently, that what the code is actually providing for is a unified set of rules that are sui generis, statutory rules, that's the phrase that Lady Hope used in the Supreme Court, and it was intended to embrace all situations. So, for example, at one extreme it can cover things like tree lopping, which I think you've actually just seen because of my learned friend's reference, the if and only if point. But it can cover that, it can cover full-scale leases, it can cover licenses, it can cover a whole series of incidental issues like entrance to the site for initial site visits in order to determine whether or not the site can be used sensibly for the installation and keeping of electronic communications codes. And it is against that framework of what we say was intended to be a comprehensive set of rules that were intended to try and cover all the situations that the code might embrace. And when one's trying to achieve that, it is perhaps not surprising that at the extremes there may well be outliers where they don't fit neatly within the framework and the wording of the code itself. But the very fact that actually you have those outliers doesn't mean that one needs to effectively put a straitjacket on and change the otherwise clear meaning of the code in order to achieve a solution for these outlier situations. And it is quite noticeable from my learned friend's submissions that he accepted that the Law Commission and indeed Parliament never ever addressed specifically the situation of concurrent leases or indeed mortgages, etc., etc. And we say that's telling because obviously those were not in the focus of Parliament's mind when this unified set code was being drawn up and put before Parliament. Can I now, having made those introductory comments, take you, firstly, again, I'm afraid, to a few bits of the code that I think we need to explore in a little bit more detail. And then can I take you back to make good the points I've been making about the way that this code should be construed. So can I first start by going to the code at paragraph 8, which, as you'll recall, is the introductory paragraph to part 2, of which part 10, of course, is part of the framework. Now that is, we say, laying down a set of comprehensive rules to try and cover, as paragraph 8 says, the conferral of code rights, the persons who are bound by the code rights, and the exercise of the code rights. So in other words, the stated aim in our respectful submission is that this is to cover all the situations. Part 2 is to cover all the situations. And that is the context in which paragraph 10 arises. We say that's part of a comprehensive package that is being put forward for dealing with who is bound and how they are bound in the code. Can I also make the point about if one looks over the page at page 418 to paragraph 11, which is also, of course, in part 2, but that makes quite clear at 11.1 that an agreement under this part must be in writing, must be signed by or on behalf of the parties to it. Now that, in our respect, reinforces the point that first and foremost, the code envisages a party to a code agreement as the actual party who entered into the contractual agreement with the other party. The purpose, therefore, of paragraph 10 is to say who else might be a party to the code agreement. And as we know from having looked at paragraph 10 2a, that is the successors entitled to that interest of the occupier who has an interest in land. And of course, in 10.6, the situation where there is what I call a 10.4 binding agreement for a person who would not otherwise be bound. So the scheme is clear, we say, that there is a single way, the original parties to the agreement were those who signed it under paragraph 11.1b, and 10 then supplements them in 10.2a and 10.6. Now, can I then look at paragraph 10.4, the 10.4 binding agreement, as I've called it, and just try and put this in some context, because my learned friend's arguments, certainly when you come to surrender, mortgage, and so on and so forth, are all predicated on the basis that you have a freeholder who grants a lease to a tenant, who then, that tenant then gives a code agreement to the occupier. And it says, well, what happens to the freeholder if in various scenarios where either the tenancy is surrendered or the tenancy is merged. But we say the starting point to all of this is the freeholder is not bound, full stop, end of story. He does not fall within 10.2, any of the list of items there, so he is not bound. And that has consequences under the code. And again, it goes back to the point I was making about the code is designed to be a comprehensive set of rules.
Or mainly paragraph 37.
Paragraph 37, my lord, and that's exactly what I was going to go to next. And it is important to see how paragraph 37 works in that situation. Because first and foremost, he's a landowner who is not bound. So on the face of it, that satisfies the condition in paragraph 37.2. The first condition is that landowners never since the coming into force of the code been bound by a code right entitling an operator to keep apparatus on the land. So he falls within that, but then he falls out because if one goes on to 37.4, the landowner does not meet the first or second condition if the land is occupied by a person who conferred a code right or is otherwise bound by such a right, and the code right wasn't conferred in breach of covenant. So the starting point is that freeholder, although not bound, still cannot get possession of the land whilst the occupier is still in occupation. But then if one takes it a step further and says, well, what happens if the occupier then ceases to be in occupation? So, for example, in the freeholder-tenant example, I started with the tenant, for whatever reason, leaves the site, surrenders his tenancy, etc., etc. And then one goes on to paragraph 40.
Hold on a minute. So the land is occupied by a person who conferred a code right or is otherwise bound by the right. That is presumably someone other than the operator.
Yeah, well, under the Compton Beecham position, that mustn't be correct.
Well, the operator doesn't confer rights, does he?
No, absolutely. But the point being, my lord, that
so this
would be the tenant in my example. He'd
so
still
this
be
is
in
where the
occupation.
tenant is still in occupation.
So if the tenant's still in occupation, effectively the freeholder cannot get the electronic communications apparatus off the land.
While the tenant's still there.
While the tenant's still there.
What if the tenancy comes to an end?
And that's what I was coming on to.
Right.
But first I should say that, of course, paragraph 37 is dealing with the right to require removal. And paragraph 40 is dealing with a secondary issue, which is enforcing any right to require removal. So if the tenancies come to an end, then the position one actually has is that the conditions under paragraph 37 are met, under 37.2 is met, and the landowner has a right to require removal. But then when one comes to paragraph 40, which deals with the right to enforce the removal of the apparatus, and one can see that paragraph 41 is predicated on the basis, this is page 444, predicated on the basis that the right of a landowner or occupier to require the removal of electronic communication apparatus under paragraph 37 is exercisable only in accordance with this paragraph. So the freeholder, because the tenancy's come to an end, now has the right to require removal under paragraph 40, but subject to its terms. And then if one goes on to paragraph 48, one sees that on the application under subparagraph 6 and 7, that is making an application to the court for an order requiring removal, then if, under paragraph 48, there's been an application under paragraph 23, i.e. for new code rights, the court may not make an order in relation to the apparatus. So there are checks and balances being built into this code to deal with the problems of people who aren't bound by the agreement, as well as laying down clear requirements as to who is bound by the agreement where one has interests in land involved. And in our respectful submission, to suggest that therefore one should look outside the provisions of the code and to landlord and tenant law in order to deal with this concurrent lease problem is simply inconsistent with a scheme that has already been put in place to try and deal with the different scenarios that might actually come up. But of course, it still raises the question of where the 10.4 agreement doesn't exist. That obviously that operators will be keen to ensure that they protect themselves. So to use the example that we've had several times, a current lease that will terminate either on 1 month's notice as here, or will come to an end in a year's time or something like that. The operator is clearly going to want to protect its position. So if one takes the position away slightly from a concurrent lease and looks at the situation where you have freeholder tenant, but the tenancy is coming to an end within, let's say, a year, and the operator wants to go on the site, but knows full well that there's only a year left on the occupier's current tenancy, then in those circumstances, he's most certainly going to want, before he puts the expensive electronic communications equipment apparatus on the land, he is most certainly going to want to ensure that there is a binding agreement in place in order to protect his rights going forward. And we say that when one comes to assess the position here, it's obvious that that's precisely what the operator Vodafone will do in these circumstances. Can I then...
but I mean, to what extent, you say you shouldn't really look outside the code,
yes,
to solve these various problems, but you do look outside the code, don't you, to explain phrases like successor entitled to that interest? I mean, well, it doesn't mean anything at all unless you've got some basic land law.
That's true to a degree, although one can obviously say that successor entitled to that interest gives a fairly clear steer, even if one didn't have the background information about the way it's normally used in real property and landlord and tenant, etc., etc. But even so, my lord, one has to start from the position that even though Parliament would be well aware of the existing law relating to, for example, landlord and tenant and so on and so forth, ultimately what it comes down to is the language clear in what it's suggesting is the outcome that the under Part 5. In other words, it has to be a party to a code agreement, either as the original party or not. One cannot start distorting it in order to deal with situations that may be unfortunate through certain eyes, but actually clearly may not have been ever in the contemplation of the draftsman when he was dealing with it. There will always be outlier situations, and the problem with trying to define a code and how it will affect everything is that where you have a whole myriad of different situations, it is very, very difficult to draft a code that will cover every single potential outlier possibility.
Well, I will be interested in due course to hear your submission on what the Supreme Court in Compton Beecham decided was the meaning of the word occupier.
Yes. Well, my lord, I am not, don't get me wrong in making these submissions, I'm not saying that one cannot look at the underlying purpose of the code, and that's exactly what I say I am doing by trying to see that it was setting out a unified approach with sui generis contractual rights. So one can take into account what the purpose of the code was, and that's, in our respectful submission, precisely what the Supreme Court did in Compton Beecham, because what they did was look at the purpose of the code in order to allow operators to get onto sites, and then construed operator in that context. But of course, that is not the purpose that my learned friend's relying upon in saying that this court should construe the code in a way that makes it a party to the code agreement under paragraph 33. Because essentially, they are saying that one needs to look at, bear with me for a moment, my lord. Sorry, I've lost the passage, but the one thing that we say is clear from Compton Beecham is that the purpose behind the code itself was to allow the infrastructure rollout and long-term investment. And that is not a purpose, we say, that necessarily assists APW in its submissions. And there's a good reason for that, we say, my lord, that if you're looking to a purpose like that, and whether or not it actually goes more in favour of APW's construction or more in favour of Vodafone's construction, we would say that the starting point has to be, should a code operator, when it is trying to understand on whom it should serve notices, against whom it can get rights, and how exactly those rights are to be achieved, should that code operator have to spend an enormous amount of time trying to grapple with the principles of landlord and tenant law, other real property scenarios, see how they interact, which has priority, and so on and so forth, in order to understand how the code works. We say that the key purpose would and should be that the code operator needs to have clear language which looks obviously clear. And we say in this case it is.
Well, you say that it's very clear the party to an agreement is, as you would expect, those parties who have signed it.
Yes.
And the only exception to that, again, you might say, as might be expected, are those who are the successors in title.
Yes.
And that's it.
That's fairly much it. Save that, obviously, we say that when you look at the rest of the code, it seems to fit coherently with it, as the example of the 10-4 agreement I've given you.
And anyone else is somebody who is simply bound by it. They're not party to it. They're bound by the rights.
Yes.
They're not party to the agreement.
Yes. Or they may not be bound by rights, as we've seen with the party who hasn't got a 10-4 agreement against it, the freeholder. So you can say there are those categories. And indeed, we say that paragraph 10.2 is effectively making a hierarchy of rights. So 10A, you have successors in title. 10B, you have parties who have derived their interest either directly or indirectly from the successor in title out of the original interest in the land, the occupier's original interest in the land. And then if one goes on to C, you see that there's a further hierarchy which doesn't in fact seem to require any particular interest in land itself. It's simply occupation. This is 10.2c on page 418. And that person can be bound by any person within paragraphs A or B. So in other words, there's a clear hierarchy that in other words, A is successors in title, B is a person whose interest in land has been derived either from O's interest or from the interest of the successors in title, and C, there's a further class of occupiers who, at the time of the occupation was granted, that were in occupation of the land, whose right to occupation was granted by O, or by a person who falls either within paragraph A or B. So in other words, we say there's a clear hierarchy of rights here as to how exactly it's done, and only one of those hierarchy, ones in 10.2a, is considered.
Isn't the important distinction that A is successors in title are people who have supplanted or replaced the party?
Yes.
And that is why they are to be treated as a party.
Yes.
Whereas B and C are people that the party to the agreement will still be in place.
Absolutely, my lord.
And it is, and the reason they are bound is because they derive their interest or their right of occupation from the party.
Yes.
So long as the party is the party, they simply are bound by the obligations that the party has.
I don't disagree at all with the way your lordship's characterised it. I simply was introducing the issue of the hierarchy of rights in order to demonstrate that it would be a very odd outcome if a party falling within 10.2b, for example, as APW has accepted and admitted on its pleadings that it does, can then say somehow, but I'm also a successor in title under 10.2a, as well as falling within 10.2b.
The great objection to that is that there is still the party. The party who has signed the agreement is still there as the party. That means then you have to have another party who hasn't signed it.
That is absolutely point one. But I'm just saying, if APW were right, it creates a further problem that they appear to fall within two mutually exclusive categories within 10.2. They are claiming that they fall within 10.2, or admitting that they fall within 10.2b, but they are saying, certainly on their alternative argument, that they are also successors in title within 10.2a. And we say that can't be right on the wording of 10.2.
Well, it might be said that if you are somebody who acquires an interest or a right under 2B or C, you need to make sure that you have the correct rights as against the party to ensure that you are not subsequently prejudiced.
Exactly, and my lord, one of the problems, this was being characterised, I think, by my learned friend as saying, well, this hasn't happened with other operators. Well, the reality is that the operators fall into the network operators fall into two camps, which is EE and H3G, hence why you see all the cases EE and H3G, and the other cases, which are effectively Vodafone and Telefonica, and what was their joint infrastructure venture, Cornerstone. So it is true that if one of the camps hasn't gone through and thought that this might be a big problem, identified it as a particular problem. But the reason we're here is because we have identified it as a problem, but until we actually have clear guidance on this, we have to serve, I think it was 14 notices in order to cover every single possible permutation, which is what we did in this case. Each one of those notices has, I think, just 2 words different in every single one of them. But that's one of the consequences of the way the notices are drafted. And so it is important to get clarification on this point. And indeed, the whole question of jurisdiction is quite important, because obviously if orders have been made under Part 5, which are not capable of being made, it is quite possible for an alert site provider in later years to come back and say, oh, well, there wasn't any jurisdiction for that code agreement, so therefore we're not going to be bound by it, and take the point at a later date. You will appreciate, my lords, I'm sure, that one of the most significant problems that there has been with the whole of the new code is the reduction in rental levels. That has caused site providers to look for methods in order to try and see if they can achieve more money out of new code agreements under the code, because obviously the levels of rent that they were used to under the old code has dropped considerably. I'm not being pejorative about that at all, it's just that this is one of the problems that drives a lot of this current litigation.
Can we just go back to paragraph 10 for a moment?
Yes.
You've described this as 10.2 as creating a hierarchy of rights, and it's only those in 10.2a who are treated as a party. That's paragraph 10, paragraph 3. What about subparagraph 4? Code right binds any other person with an interest in the land who has agreed to be bound by it. Is that person a party to the agreement?
It must follow that he is being treated as a party to the agreement, because if one looks down at subparagraph 10.6,
exactly,
one sees in clear terms that successor in title who is bound by a code agreement by virtue of paragraph 5a is to be treated as a party to the agreement by which P agreed to be bound by the right.
He hasn't signed the agreement in the sense required by paragraph 11, has he? He's just agreed to be bound. He's just agreed to be bound by it.
Yeah, he will have, yes, because in order to be a 10.4 agreement, that agreement must be signed by or on behalf of the parties to it. And the parties to it will be that freeholder, to use the example, agreeing to be bound with the code operator by the rights that have already been conferred on it by the occupier under paragraph 10.1.
So agreement under paragraph 10.4 means that the person agreeing is a party to the code agreement.
Yes.
Must admit, I really don't agree with that.
Well,
may I just yes. How I read it? 10.4 says that you enter into an agreement, or agree to be bound by it, is the code agreement. So 10.4 is looking at a further agreement. Call it, it's the to be bound by the code agreement. And what 6 says is a successor in title who is bound by a code right by virtue of such an agreement is to be treated as a party to the agreement by which P agreed to be bound by the right. Now, that is not the code agreement, that is the further agreement.
Yes, sorry, that's...
So
maybe I said yes
it's
too
not
quickly.
saying, just let me finish for MMA, it's not saying that the successor in title in that situation is a party to the code agreement. It's very definitely not saying that. It's saying that he's a party to the agreement by which P agreed to be bound by the code agreement.
Absolutely, my lord, but I think the difficulty we are having here, and I picked it up in the course of Maloney Friend's interchanges with the court earlier this morning, is that one has to be very careful about recognising that paragraph 20 does not only provide for code rights to be conferred, it also provides for code rights to bind parties. So in other words, under paragraph 20, part 4, you can apply for code rights that not only may be conferred by a party, but which may also bind that party. And as a result, if you want to call them conferring agreements or binding agreements, they are still agreements under the code, but obviously they will be different agreements because a party that is bound by rights may not necessarily be able to confer the rights. I think that's the point that where the confusion may be coming, is that a code agreement can be both binding or conferring, and they may be different agreements. You may have an agreement. So for example, to take my freeholder example, the tenant grants a code rights to the operator, but the operator, for whatever reason, also wants the freeholder to be bound in, for example, if there's a short notice to quit provision. And so it then will seek a separate binding agreement against the freeholder in order to tie it in.
Or freeholder grants the code right and the operator wants the mortgagee to be bound.
Well, that could be another example, but of course, in a sense, that's not the example that Maloney Friend is using, because Maloney Friend's using the example of where the code agreement is granted before the mortgage. I think the example your lordship is putting to
it's granted after the mortgage, but you want the mortgagee to be bound by it. So you go under paragraph 20.
Well, one could do that. There's nothing to prevent one from trying to bind in anyone who one thinks needs to be bound in order to protect one's code rights. But the example that my learned friend gives of the mortgagee in possession is predicated on the basis that the code right has already been conferred, and so therefore the mortgagee must take subject to that right in any event.
I'll go back to the question where I think we started on this line. Looking at 10.4, 10.4 is talking about whether a code right binds somebody else. That's someone who wasn't a party to the original conferring agreement.
Yes.
And they are bound if they agree to be bound by it. And as you say, that seems to envisage a separate agreement. It's not the conferring agreement.
Yes.
It's a binding agreement.
It's a separate agreement.
Yes, and I think that's what Judge Cook referred to as a secondary as opposed to a primary agreement.
Yes.
And as my lord pointed out, paragraph 10.6 refers to that agreement as the agreement by which P agreed to be bound. But it still leaves unanswered the question whether P is a party to the conferring agreement.
I think the short answer to that is certainly on the language, no, he can't, because it's a separate agreement.
So, by his secondary agreement, he agrees to be bound by the code right.
Yes.
But that doesn't make him a party to the conferring primary agreement by which O agreed to confer the code right. Is that right?
That's right, but of course the binding agreement is almost certain to be coterminous with the conferring agreement. So, for example, it would be very difficult to imagine that a freeholder would say, I agree to be bound for, well, I can, perhaps I should start again on that point. For the most part, if one says, I've got an agreement for, let's say, 15 years, the tenant is in occupation for 15 years, but I want to cover myself in case there's a surrender or in case there is a notice to quit or whatever other reason might be caused there. it is very unlikely that the freeholder would, in those circumstances, be granting a binding agreement, i.e. the separate binding agreement under 10.4, for a period longer than the original code agreement. Of course, you might get situations, and the concurrent lease of 1 year is one example, where in fact you want to bind the freeholder for a much longer period.
Yeah, tenant's got a year to go, and he wants 10 years to recoup his. The operator wants 10 years to recoup his investment. Yes. So he wants the freeholder to be bound for the remaining 9.
For the remaining 9, exactly, my lord. But in our respectful submission, it would still be possible in those circumstances for the binding agreement to continue under paragraph. Well, it would continue under paragraph 30, open brackets 2, close brackets, even if the conferring agreement had come to an end much earlier on.
Well, it seems unnecessarily complicated. If the freeholder is willing to be bound for 10 years and the tenant's only got 1 year left, why make them go through this whole rigmarole under Part 5? Why can't you just have an agreement which lasts for 10 years? Binds everybody who agrees to be bound by it.
Well, one will then have the situation where if the concurrent lease has come to an end after 1 year, one would have the situation where effectively that party would no longer be conferring any rights, and it would have indeed left possession, so therefore could not by any stretch of the imagination be deemed in occupation with the contribution
picture, leaving the remaining 9 years of the code agreement binding the freeholder. What's wrong with that?
But there's nothing wrong with that, my lord. I'm sorry, perhaps I'm misunderstanding the point that was being put to me.
But on that scenario, you still say the freeholder was not and does not become a party to the code agreement.
Well, he becomes a party to the binding code agreement, and that is the one that goes forward into Part 5. Part 5,
But he's only agreed to be bound on this scenario under 10.4. You've just been saying that doesn't make the freeholder a party to the conferring agreement. So does he become a party to the conferring agreement when the tenant drops out of the picture, or does he never become a party to the conferring agreement?
I think the preferred route is that he would simply remain as he was, a party to the binding agreement.
Yes.
The binding agreement.
So he's never a site provider who is party to a code agreement.
Well, he is, my lord, with the greatest respect, because if one goes to paragraph 30, at 31 we get the definition of site provider. A code right, subparagraph 2 applies if a code right is conferred by or is otherwise binding on a person, the site provider.
As the result of a code agreement?
Yes, and the code agreement being discussed here is the binding agreement.
Yes, yes, but he's a site provider.
So he's a site provider.
So the code right is binding on the freeholder, the site provider, as a result of the code agreement.
The binding code agreement.
That is the 10.4 agreement.
Yeah, that's the 10.4 agreement, yes. And then he clearly is a site provider who is party to agreement, if one goes on to paragraph 33.1, an operator or site provider who is a party to a code agreement by which a code right is conferred by or otherwise binds the site provider. So he's a site provider and he's a party to an agreement who is otherwise bound by, he's party to a code agreement by which he's otherwise bound. The language could have been perhaps constructed a little bit better, but what we say is clear from that is that the binding code agreement falls within the provisions of paragraph 30 and 33.1, and that is how you deal with the freeholder who's been bound by a code agreement under 10.4. I don't think anyone pretends that the language of the code has necessarily been drafted in the most felicitous of ways, but if one works one's way through it, one can usually find that there is some method in the way it's agreement's actually been drafted, and we say that that's precisely what's happening here.
So can I be clear about this, that the code agreement is defined by 29.5 as an agreement to which this part, that's part 5, applies.
Yes, but one has to, and this was...
And that applies to, by 29.1, agreements under part 2.
Yes.
Your submission is that it's not just a conferring agreement, which is the only way in which code rights can be conferred. That's 9. A code right may only be conferred by an agreement between the occupier and the operator. So the freeholder is not the occupier, so he's not a party to a conferring agreement. But the 10.4 right, the agreement, which is the binding agreement, to which the freeholder is party, is also an agreement under Part 2 of the Code, and then also a code agreement under Part 5?
Exactly, my lord.
And subject to Clause 11, paragraph 11.
Yes, I think the point that's being put to me from those behind is that perhaps I wasn't carefully distinguishing the current situation from the example I was giving of the freeholder. In this case, of course, what Vodafone has served on all the parties is one single agreement, which respectively tries to bind in and confer the rights at the same time, which is in many ways the ideal way of actually doing it, because then you have a very clear position of the conferrer and the binder being bound by the same, being involved in the same agreement, and therefore the conferrer agreement and the binding agreement is the same agreement. And of course, that's probably, if one had the example of an operator going to in the situation where you have a freeholder, a tenant, and the operator wanting to get a longer lease than longer contract code agreement than the than the tenant can currently offer. In that situation, that is when you probably also seek a tripartite agreement, so that they're all locked into the same agreement, and so therefore there is no dispute going forward as to who exactly is the party to the code agreement for the purposes of paragraph 30. Yeah. It goes back to the point I was making earlier. The trouble with all of this code is that one can always postulate outliers that seem to cause problems in interpreting the code. But one just has to, in my respectful submission, recognise that there are inevitably going to be outliers, and those will just have to be done on a case-by-case basis, rather than trying to import principles into the code that the language of the code itself does not recognise. Can I just briefly look at my notes and see if there's anything else I should be referring to on the actual language of the code? I think your lordships already have it that obviously 10.2a is not simply referring to a successor in title, but is a successor in title to that interest. Yeah. And that's quite significant when one comes to consider the alternative argument by APW that they are somehow a successor in title under paragraph 10.2a, because clearly, as the Upper Tribunal recognised in the judgment, they are not successors in title to that interest, i.e. the interest of Gencomp. Can I just deal with one other point that didn't seem to be pressed in oral argument, which I do want to make, is that the argument raised in the skeleton argument that the paragraph 10 is necessary in order to transfer the burden which otherwise wouldn't happen. We respectively say that is just inconsistent with the language used in paragraph 10. Paragraph 10 is clearly dealing with property rights, the successors in title, interests in land. And in our respectful submission, it cannot be right that paragraph 10 was inserted simply to deal with contractual agreements. It must have been inserted there in order to deal with interests in land, as the code actually says quite clearly. As regards...
Sorry, I haven't understood that point.
Well,
I thought the point that was being made against you was that you don't need paragraph 10 to deal with the position where the operator has a lease, because leases look after themselves. What you need paragraph 10 to deal with is the case where the operator only has a license. Now, I see that paragraph 10 refers to interests in land, but it's referring to the site's provider having interest in land. It's not dealing with the operator, the nature of the operator's interest, is it?
Absolutely, my lord. This is what is unclear. I was trying to find the reference to the skeleton argument where this point is actually made by APW. But their argument is exactly as you said, that leases look after themselves. So this is dealing with the assignment of personal contracts. But of course, the contract one would be considering in that situation is not any contract between the occupier and the operator. It is the occupier's interest in the land. So in other words...
No, I thought the point was this. At common law, if I'm a freeholder and I grant you a license to put up apparatus on my land and then sell the land, that doesn't bind my purchaser, because it's a license. And
yes.
Licenses don't bind purchasers. The code is obviously intended to stop that by making licenses binding on purchasers. Now, I thought the point that was being made is that's really what paragraph 10 is doing. It's dealing with the case where the operator only has a license interest and not a lease interest, because you don't need a paragraph 10 to deal with lease interests, because the law has been worked out over centuries. Now, that may not be a good point, but that seems to me to be a different point from saying, look at paragraph 10, it refers to interest in land itself, because the interest in land it's referring to is not the operator's interest, but the site provider's interest. Have I misunderstood the point?
Well, I think you've probably put the point far more cogently than perhaps it appears in the skeleton argument, because it wasn't clear to us which agreement they were actually focusing upon when making the point. But our point is that obviously it's providing a unified set of rules.
Yes. So you say it applies to licenses,
absolutely.
Licenses, leases. It's meant to deal with everything.
Yes, and indeed, if it was trying to deal with the situation that you've just postulated, it still doesn't seem to us to be a very clear way of making that point going forward.
I think we're all agreed it's not very clear.
My Lord, I'll move on. I'm sorry, my Lord, it's just that obviously quite a number of the points we've already touched upon already. Can I therefore just finally finish with looking at paragraph 29, which we say does give a very, very clear steer on the agreements that were contemplated within Part 2. Because it's quite clear in our respective submission that although code agreement is defined in paragraph 29.5, that is derived from the system of going through paragraph 29.1 in order to relate it back to agreements under Part 2, and then it strips out certain leases in subparagraphs 2 to 4. Now, we say that really deals with the point that's just been made about paragraph 10, that plainly it was recognising that paragraph 10, as part of Part 2, was dealing with leases as well as licenses and so on and so forth. So in other words, it's quite clear, we say from paragraph 29, that that Part 2 was intended and always intended to deal with leases. It's just that when you get to Part 5, certain of those leases are removed from the definition of the code agreement. So that
I don't think it's disputed that Part 2 applies to leases, but generally.
Well, at several points in Maloney Friend Skeleton argument, he refers to leases looking after themselves. And
no, that's to do with who other than the original landlord is bound by the lease. I don't think it's ever been suggested that Part 2 doesn't apply to leases.
No, but once one, I suppose the point that I was making, my lord, is that once one accepts that Part 2 applies to leases,
yes,
it then becomes very difficult to see why one should necessarily then assume that Part 2 also intended that elements of landlord and tenant should be read into it, or outside of the agreement with it, with the language within paragraph 10, leases should have some independent existence. Because the Learned Friend's primary argument is that he can be a party to a code agreement independent of paragraph 10. Yes. Paragraph 10 is not exclusive. And we say that that can't sit with paragraph 29, 1 to 5, which clearly indicate that leases were always considered to be part of Part 2, and therefore it would be somewhat odd if the effect of paragraph 10 could be supplemented in somehow by landlord and tenant law, in addition to the wording already of paragraph 10.2. That's the only point I was making. Thank you. Well, Lord, can I then move on to how one should actually approach the construction of the code agreement? First, we say that the code was designed as far as possible to be a self-contained code. And that point, we say, comes out of the decision of this court in the case of University of London and Cornerstone, which is at tab 11 in the first authorities bundle at page 231. And perhaps, my lords, I can ask you just to briefly look at it. So the first authorities bundle, tab 11, page 221 is the starting point. And this case involved, which is one of the first to hit this court on the code, involved the question of a interim code application under paragraph 26, which involved whether or not an operator could obtain under that paragraph the right to go in and inspect a site to see if it was suitable for the inclusion of electronic communication apparatus. And one of the big issues was, well, there were two issues. The first issue was whether or not the code rights actually encapsulated such an initial investigation. And the second point was whether or not the language of the code required a operator to issue not only the paragraph 26 application relating to the interim rights, but also a paragraph 20 application. Now, if I can ask one to the court to go to paragraph 26, which is on page 230. Sorry, paragraph 27. One sees there that on the first argument, the starting point for the university's argument advanced by Mr. Clarke is that where pre-existing provisions enabling an operator to enter land about which Parliament was taken to know, and which are not being reproduced or incorporated into the code, since Parliament has omitted to incorporate or reproduce these rights in the code, the inference is they did not intend such rights to be code agreements. Code rights, sorry, thank you. And then at paragraph 34, the court rejects that. We do not regard this argument as a strong pointer towards the correct interpretation of the code. As the Law Commission said, the code was to be drafted on a clean sheet of paper. The code was thus designed to be, so far as possible, a self-contained code, And the answer to the first question raised by this appeal must be found within the words of its code itself. And we say that that's exactly what the court should be doing in this instance, looking to the words of the court code themselves and not necessarily concentrating on features outside the code in order to...
So that was a completely different point.
Well, it is a completely different point, but my Lord, we say it's a principle.
It may be a self-contained code, but it's not enacted in a legal vacuum.
No, I agree, and I don't dispute that. But what I do submit is that the starting point ought to be to look at it as a self-contained code and see whether or not the language of the code needs to be supplemented in some way, and where that and there should be, in our respectful submission, a bias against doing that, given that it was intended to be self-contained. That's the point I make out. I would also very briefly refer to paragraph 62 on a separate point. This was dealing with the second question, which is whether or not it was necessary for there to be a paragraph 20 application as well as a paragraph 26 application. So this is page 236 in the bundle. The Law Commission's intention in recommending the power to grant interim rights was to enable early access for the purpose of exercising code rights while any dispute about the compensation payable for or other terms of full-blown agreement was resolved. And that's clear from the paragraphs cited. And that basis was relied upon heavily for saying that there needed only to be there needed to be a paragraph 20 application as well as a paragraph 26. And then at paragraph 67, it stated, it is in our view fair to say that these statements of policies both before and after the enactment of the code support the view that paragraph 26 was primarily intended to fill the gap between the making of an application under paragraph 20 and its final determination. The question for us, however, is whether the code as actually drafted goes further. Neither statements of policy nor explanatory notes can dictate the proper intention of the legislation. And again, we say that that is an important principle to be adopted when considering, as my learned friend presses, the Law Commission's intentions. Because the fact that the Law Commission may have wanted some particular features like leases looking after themselves to be dealt with does not mean that that is what the code has actually prescribed. And indeed, we say the starting point has to be the language that is actually used. And then finally, my Lord, again to reinforce the point that this is really a sui generis statutory code that needs to be looked at on its own, I'd refer you to paragraph 117 of Compton Beecham. I want to come to Compton Beecham in a little bit more detail in due course, so I'll take you to it then. But it was made quite clear there the code was to be a sui generis set of statutory rules which use contractual agreement as their foundation. And we say again, that's an indicator that one must look to the language of the code first and foremost. My Lord, I think I've already made the point at some length about the way that this was a code that was intended to cover a whole range of different issues. If one wants authority for that, and I don't necessarily ask you to turn it up, but for your Lordship's note, this was the point that was made in paragraph paragraph 44 of E and H3G against the London Borough of Islington, which for your reference is first bundle of authorities, flag 10, page 196. It's made quite clear there.
Sorry, which paragraph?
Sorry, paragraph 44. But, well, my Lord, perhaps I should take you to it rather than just giving the reference. So it's tab, authorities bundle 1, tab 10, page 196. I may have, unfortunately, given the wrong reference. Yes, it is tab 10, my Lord. So it's Ian Hutchinson 3G v Islington London Borough Council. That was a case about code rights, and in particular compensation. One of the issues that came up was whether or not a lease could actually be granted, and surprisingly enough, the site provider was objecting to a lease being granted in that case. And there, the Lands Tribunal made it clear that at one end of the spectrum, code rights may involve going onto land for a short period to cut back trees or carry out a survey, so on and so forth. So it's really just reinforcing the point that I made earlier, that this was intended to be a unified code that dealt with a number of different situations. Now, can I just deal with the purpose behind the code? And at this point, I would ask you to take Compton Beecham. I know you've already been to, but it's in the second authority bundle at tab 14. I'm sure one doesn't need to go over this in too much detail, but if I can ask you simply to go to page 294, paragraph 1 of the Lady Rose's judgment, where it sets out fundamentally the intention behind the code, which is the rollout of digital communications infrastructure. If I can ask you simply to go on then to page paragraph 88, my Lord, I simply draw attention to the fact that AP Wireless does use different label mechanisms, and paragraph 88 shows that in one of the cases there it didn't take a concurrent lease, it had a freehold. And so it is possible to circumvent any perceived problems in the code language that APW says is there by simply using a different type of approach. And then can
I haven't quite understood how that works with a tower on top of a bar. Wouldn't really be very sensible for APW to take a flying freehold of a tower, and the owner of the bar presumably wouldn't want to sell the whole thing.
Well, the point, I suppose, that all of this emphasises is that there is going to be a case-by-case approach to it, so that concurrent leases, which were used in one circumstance, may be better. It may be a better solution to actually use a freehold transfer. But in a freehold situation, of course, you know, the position is that often with a lot of these rooftop code agreements, is they're not actually leases. They are, in fact, contractual agreements, mere licenses to use the roof. So there are a number of very, very different situations that can arise under the code. And to read in our respectful submission the code to deal with one particular problem is not the right solution in our respectful submission.
Thank you.
If one can then look at paragraph 100, one sees the core problem, which I think your lordships are all obviously well aware of, which was the definition of occupier in paragraph 9. And the contention by the APW, actually, as it was, for that the occupiers could include operators in situ. And the contentions on the other side that, in fact, you have to ignore the presence of the operator when deciding about the conference of rights. And then at paragraph 102, we come to the point that I start from the proposition that the word occupier, when it appears in different statutory contexts, has no fixed meaning but must take its content from the context in which it appears and the purposes of the provisions in which it is used. And there's then a discussion about that. And then one comes to paragraph 117, which indicates that both the old code and the new code indicate the negotiation of voluntary agreements between the parties to confer of code rights is the optimal way for the regime to operate. Just pausing there, my lord, it is fair to say that with vast swathes of code arrangements, they are done consensually. And the difficulty that perhaps the courts may assume is that there are ongoing and continual difficulties between operators and site providers. That is not true.
Well, of course, I mean,
you're seeing the tip of the iceberg.
This court only sees the ones that have gone wrong.
Yes, you're seeing the tip of the iceberg. And so the idea, for example, that it's necessary for a concurrent lessee who wants to redevelop a site, say a long lessee, that it's going to be seriously prejudiced by not having the right that my learned friend says it should have under the code agreements, simply very, very unlikely to materialise. Because the reality is that such a redevelopment is going to take in an enormous number of other factors, for example, having to negotiate utility rights, land access, archaeological investigations, environmental investigations, and so on and so forth. And the negotiation about code agreements will simply be one part of that whole negotiation process. So it's a slightly interorum argument that's being raised that somehow or other this may scupper some massive redevelopment because a concurrent lease might have been used. The reality is that these things will be dealt with consensually. And the point in aid of that, we do very strongly rely on the fact that operators are regulated. Under the code, they only have the code powers if they get a direction from Ofcom. Ofcom regulates them in a whole number of other spheres as well. So, for example, they may well have access obligations on them. They may well have significant market provider obligations on them. And the idea that an operator is going to be completely difficult in scuppering a large redevelopment, it is simply ignores the fact that they will not want to be seen to be unreasonable in front of the Ofcom, because Ofcom has immense powers it can use against them, and that there is, if you like, a leverage that all of them know that they cannot use. So they can't be bloody-minded, to use that expression.
But it's not so much the comprehensive town centre redevelopment, it's the putting the extra flats on top of the block.
Well, that certainly wasn't the example being used in the tribunal below. It was the large shopping development example that was being put forward. But still, in our respectful submission, there are ways and manners by which that can be dealt with. I should perhaps come back to those to actually deal with the question of redevelopment and how that might pan out, because I obviously want to sort of, my primary aim now is to look at the purpose of the code itself.
It's also true that negotiations between commercial parties take place against the background of what they perceive their legal rights to be if they were to litigate. So the very fact that we don't get litigation over a case doesn't mean that what would happen if you were to litigate is unimportant.
That's always true, that if the parties have a clear certainty around the law, then when they negotiate in order to deal with any aspects of that. But that will be true going forward. It's the point the Upper Tribunal made, that in light of its decision and how the code operates, parties would be able to take forward that knowledge in the way they actually structured their deals. So the large redevelopment is one thing. The concurrent lease on a rooftop may well be structured in a different way. It may not be a frying freehold. But the other point, and perhaps I will deal with this while we're on the subject, is that on our case, the concurrent lessor is still a party to the agreement.
Yes.
So therefore, it still has rights under paragraph 31. And earlier today, we obviously discussed the question of obligations to repair and so on and so forth, and indeed to redevelop the site, because in this particular instance, it's far more likely that Gencomp will want to redevelop aspects of the building that may require the removal of the electronic communications equipment apparatus off the site in order for them to carry out those major restructurings. And there's no reason in our respective submission why, in that type of situation, the concurrent lessor shouldn't come along and say, I want to redevelop. But even if one's looking solely at the situation for, if you like, the extension on the roof, it's quite likely for most of these deals that they will actually, the benefit to the concurrent lessor will not be realised until the plans to redevelop have come to fruition. So, for example, they might be subject to planning being obtained, etc., etc. It is possible to see it the other way, but often these agreements will be structured on the basis that the concurrent lessor only gets the benefit when the rooftop building goes on and is completed. Now, in that case, if it loses out because the ECA remains on the rooftop, then it is perfectly possible for it to apply under paragraph 31D and say, I'm suffering severe prejudice by this ECA remaining on the rooftop. It needs to be removed, otherwise I do not get the full amount of my bargain. We respectfully submit that the tribunal has been very astute when people are suffering prejudice. My own friend indicated earlier on that there weren't many cases where people have been able to show prejudice, and he referred to one. But the tribunal in that particular reported case, and I know because I was involved in it, were very, very, very astute to make sure that the landowner did not suffer financial prejudice by being able to carry out its redevelopment. So there are ways and means by which, even though the concurrent lessee may not be able to use paragraph 31, the concurrent lessor may well itself want to actually use it in order to get rid of the electronic communications apparatus. If I can return to paragraph 117 then. So we see that's even more central to the new code, in which court orders in default of agreement under paragraph 5 of the old code are replaced by imposed agreements under part 2 of the new code. Given the centrality of code rights, the operation of the whole regime, and the creation of this sui generis form of statutory rights which use contractual agreement as their foundation, it seems the fundamental premise of paragraph 9 is the operator and the occupier of the land are different persons. And that is how the Supreme Court effectively reached the decision that it did. But the core point is that it recognises...
Yes and no. Because having said that the occupier of the land and the operator were different, it then went on to dismiss the appeal, because they then went on to restrict the carve-out, not simply to the operator, but to the operator who was seeking new rights.
Yes.
So if one asks oneself, what is the meaning that they ascribe to the word occupier in paragraph 105? What is your answer?
My answer is that it is the person who effectively is the one who can occupy the land, subject only to an operator being in occupation of the land itself. So you disregard the presence of the occupier, of the operator. But that operator must be, obviously, the operator who is involved with the code agreement. It cannot be, for example, a third party, as in...
Well, that's certainly what they decided. Apart from the principle, with one bound he was free, what is the principle of statutory construction which they applied in order to reach that meaning?
The principle, we respectfully submit, is that they looked at the purpose of the code. They looked at the code and decided that the rollout of electronic communications apparatus was core to the whole purpose of passing the code in the first place, in the form that it actually was. Given that, they then decided that operator could not necessarily have the same status as occupier, where the operator was the subject of the code agreement. But my lord, if you want me to try and write down a definition of how occupier actually turns out as a result of the Compton-Beecham decision, then obviously I would try and do that overnight.
But, well, it's the principle which they said they were applying, which I find difficult to discern. I mean, I understand that they found the result we arrived at in the Court of Appeal unpalatable, and it wasn't a very sensible result, and they've said, well, this is the sensible result, that's what we're going to say the language means. But, I mean, quite a lot of attention was given in the Upper Tribunal in this case to orthodox principles of statutory interpretation, but I find it difficult to see what orthodox principles of statutory interpretation led to the result in Compton Beecham.
Well, perhaps I can answer the question like this. That clearly what they accepted was that the word occupier did not have any set definition within the context of statutes generally. And they obviously refer, and I think it's earlier in the judgment at paragraphs 104, leading on from the different statutory contexts, 104 onwards, to instances where the House of Lords made it quite clear that the concept of occupation is not a legal term of art. Now, having done that, they then obviously took the view that one clearly must define occupier in the context of the particular code that was, particularly statutory provision, in this case the code, it was being used, particularly when put against the purpose of the code, which obviously was to roll out, to ensure the rollout. They noted obviously a number of problems connected with the construction that APW in that case were pushing for, and in light of that, and in light of several other textual indicators, they decided that occupier was not necessarily synonymous with the party in occupation of the land, if that party was an operator, because the idea behind the code
if that party was an operator seeking code rights.
Yes.
Because the reason that the appeal failed in Compton Beecham was that Vodafone, an operator, were in occupation, but weren't seeking code rights.
Yes, it was Cornerstone seeking the code rights, yes. And again, that's logical, because it is this sort of carve-out that they actually produce in order to achieve that. I mean, well, one could debate the issues surrounding the Supreme Court, but what one has to be is obviously guided by what they say.
I entirely agree, and if I may say so, I think their solution is perfectly sensible. It's just the question of how you get there.
Yes. Well, my Lord, what I was primarily concentrating on was obviously the structure of the code, and I've taken you to obviously 117. And then if one goes on to look at 118, one sees the concerns as to what they thought were A, the consequences of APW's construction, and B, also how that fitted with the purpose of the Act, with the code. And as one can see, that they made it quite clear that it goes back to the original purpose, namely allowing the long-term contractual terms of the agreement, and that they needed long-term fixed interest in order to justify their investment in installing the electronic communications apparatus on site. But on the other hand, that this is an industry in which technology develops very quickly, and where the government policy is that new improvements to digital infrastructure are rolled out across the country swiftly. The concern that rights will be frozen during the initial term and cannot be supplemented by a new agreement, Part 2, has the parties told us, the operators insist on including all the code rights set out in paragraph 3. So the effect of unintended consequences that actually was creating more problems by ignoring, by having a construction that ignored the underlying rationale behind the code. And one sees that indeed when one looks at paragraph 126, where Lady Hope agrees with the concerns raised by Judge Cook in the on-tower judgment. The construction contended for by AP Wireless encourages operators to engage in the wasteful and pointless expense of either moving to a neighbouring suboptimal site or removing the ECA, applying for new code rights under paragraph 20, and then moving the equipment back on site. So that's we say the background to how one should actually, the purpose behind which one should actually take into account when looking at the code. Can I just ask you on a different point, as we're here, I'd quite like to take you to it, is paragraph 122, where it's dealing with a point raised by counsel on behalf of APW. So this is page 318. Secondly, if the code is supposed by the mechanism of paragraph 9 to prevent the operator from being able to change its rights during the initial fixed term, that has only partly achieved. Mr. Piermont for APW accepts that there are some operators who install electronic communications apparatus on site, but do not thereby become occupiers. For example, if they merely fix antennae to a roof or have access right over land. And this goes back to my point that there are instances where rooftops are actually done by license rather than by lease. Such an operator who is not an occupier is entitled to apply for more code rights against the same landowner who has retained the status of occupier for paragraph 9 under paragraph 20. I agree with Mr. McGee on behalf of Cornerstone submission that this makes the application of part 5 of the code arbitrary, that there is no discernible policy reason for limiting paragraph 20 in this way. Now, the reason why I draw your lordship's attentions to that is, of course, that my learned friend's arguments are all fixated on the idea of the code agreement itself being a lease. But of course, where the code agreement is a license, it is very, very difficult to see how a subsequent tenant coming in over effectively its head can become party to a code agreement in those circumstances. There's no privity of estate, so therefore there is no question of his argument, namely that the lease looks after itself and makes that party to a code agreement, applying in those circumstances. So in other words, at best, his solution of somehow paragraph 10 having a wider meaning, or paragraph 10 including successors in title, subsequent leases, lessees, doesn't work where the code agreement is a license. It falls down at that point precisely because it cannot become a party to a code agreement where that code agreement is a license. And we say that's quite an important point again, because it mirrors APW's point being made in the Compton Beecham case, that if their answer only provides a partial solution, that in itself suggests it may not be the correct
Well, I must say, I thought that what Mr. Plymouth was really saying is what Lady Rose deals with at paras 127 and following. What he was really saying was, irrespective of whether the code agreement is a lease or a license, what the code is supposed to do is to prevent the operator from being able to change its rights through the initial term.
Yes, when part 5, in whatever manner it does, applies. Absolutely right, and that's another point I was obviously going to come on to when dealing specifically with the language of the judgment that my learned friend relies upon for saying that once part 5 is kicked in, nobody else can get a part 4. But this is a slightly different point where I think he was trying to argue on the precise definition of paragraph 9, and he was saying in terms that it meant that you needed the protection of saying that the operator in situ was the occupier, because that was the way that you could stop them effectively trying to go back on their code agreements and try and negotiate new rights. What Lady Hope obviously said in that paragraph was that, yes, but that doesn't actually provide a solution where the operator is not in fact in situ but only has license rights, and so therefore can't be considered to be an exclusive occupation and therefore can't be considered to be an occupier for the purposes of the code. And if it's only providing a partial mechanism for solving the problem, then it's not a good mechanism. Sorry, I've laboured that point a little long, but it is. We say there's a direct analogy with what the learned friend is putting forward on that. on his argument.
Well, Mr. Reed, would that be a convenient moment to break?
Yes, my lord. I'll have a look overnight and see if I can cut some of the submissions down so that you're not troubled for too long.
Right. All right. Thank you both very much. 10:30 tomorrow.
All right.